Hey, everybody. Let me know if I sound okay. Hey, everybody. Let me know if I sound. Oh, there's some people coming in pretty quick. Hello. Get everything situated here. There we go. Hey, everybody. Oh, good crowd going. Exciting. Oh, sorry about that. So, yeah, let's just go ahead and get started. Sound okay? Loud enough? Sorry, still getting used to all the settings and everything. But, okay. Oh, hey, Matt. What's up? I know there's a big Betero letter. I haven't read it yet, but I know that that's kind of the talk of the day. So people, I think Aiden's going live in about an hour, so I won't be offended if people want to drop off to hear that. But I'm just going to go ahead and get started with this. So this is the first motion that we filed, myself and Tiffany Adams, on behalf of Antonio Sledge, as you can see there, also known as Mounk, in connection with his probation revocation. I'm going to try not to comment too much on stuff outside of this document because I just really want to explain this motion in particular. I know there are parts of it that are confusing, and there are parts of it that require a lot of background that people might not have. I don't mean that in a pejorative way. Just, there's a lot of stuff that wasn't presented at trial that if you just watched the trial, you might not have gotten. So yeah, let's get into it. Motion to vacate void sentence. Okay, I'm going to go against what I just said. One thing you need to know about motions to vacate sentences is you can only argue that the sentence is illegal. You can't argue about the conviction or the revocation itself. So that's why I'm not going to be discussing in this motion or in the next one anything about the sort of the procedure. That's not really something you can do in this motion, but that's something we'll be discussing in the very near future. I don't know what this means. It's Georgia stuff. So here we go. Comes now Antonio Sledge by and through his undersigned counsel, me and Tiffany, and respectfully moves the court to vacate his sentence pronounced on December 28th, 2022, as Mr. Sledge was sentenced to 15 years to serve on probation for count 30 OCGA 1611-131B. That's possession of a firearm by a convicted felon, which exceeds the statutory maximum for the offense of conviction and is therefore void. That just means the maximum sentence is either 5 or 10 years, depending on the circumstances, and he got 15, and 15 is more than 10. So it is void. The final disposition is attached as Exhibit A. In support of said motion, Mr. Sledge shows this court the following. Oh, and you can jump in with questions. I'll try to answer them as soon as they pop up. Statement of facts. Mr. Sledge was originally indicted on May 9th, 2022, under case 22 SC 182273. The original indictment is attached. The original indictment charged Mr. Sledge in count 1 with the RICO conspiracy and count 2 with possession of a firearm by a convicted felon. I guess I can do a little show and tell as I go. me make sure there's no comments on this. Yeah, that's fine. This is the original indictment. You can see this is inexplicably not in perfect order, but here we go. This is Mounk, Tounk, Antonio Sledge. You'll see counts 1 and 30. Count 30, possession of a firearm by a convicted felon. And count 1 is up here. This is the RICO conspiracy. Okay, so that's what he's charged with in the original indictment. Let's see. The language of count 30 in the original indictment reads, in the grand jury's aforesaid, I can just show you this actually. This is the original indictment. The grand jury aforesaid in the name and behalf of the citizens of Georgia do charge and accuse Antonio Sledge with the offense of possession of a firearm by a convicted felon. For the said accused in the county of Fulton on the 5th day of December 2021, did knowingly and without lawful authority possess a firearm, to wit a handgun, after having been convicted of a felony in indictment 15 SC 138994 in the Superior Court of Fulton County for the offenses of participation in criminal street gang activity, ag assault, and ag battery on the 10th day of January 2018. So because he had that felony, I have things to say about it, but that'll have to wait. He wasn't allowed to possess a firearm, and they say that he did. On August 5th, 2022, the district attorney, Bonnie Willis, re-indicted the case under 22 SC 183572. That's also attached. With respect to Sledge, the caption of the re-indictment was not revised from that of the indictment. So let me show you that. This is the re-indictment, and you'll see Mounk, Tounk is here. Still says 1 and 30, which is correct. Count 30, possession of a firearm by a convicted felon. That is the same in the indictment, which is on your screen now. Possession of a firearm by a convicted felon. I don't like this. There we go. This is the re-indictment, so you see it's the same thing. They did not change that count. And with respect to count 1, you'll see that they're also the same. Count 1's not a problem. I just want to show you both. So they are the same. And for both counts 1 and 30, on this part, on the face of the indictment. So when you look at it on its face, you'll think it's exactly the same. Let's see. As in the indictment, count 1 charged the conspiracy, and count 30 charged possession of a firearm by a convicted felon. However, within the body of the re-indictment, count 30 was altered in at least 2 ways. The first change to count 30 in the re-indictment, in the body of the re-indictment, was the name of the offense charged. It was changed from possession of a firearm by a convicted felon to keep calm and indict on, to possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm in violation of Georgia law pursuant to OCGA 1611-133. There are several things that are, I would say, funny, but not haha funny. More like, I'm not going to do a segue on that right now, but I will soon. Or a segue, not a segue, what's the word I was looking for? Aside, I guess. Here we go. So this is the original indictment. Possession of a firearm by convicted felon, 131. Possession of firearm by convicted felon, previously convicted of felony involving use or possession of a firearm, 133. Now, one thing you need to know is 133 carries a substantially more significant penalty. It's a mandatory 15 years. It can be on probation, but it's a fixed 15 years, and it must be served consecutively to all of their sentences. So really it's an additional, in most cases, if you have multiple convictions, it's going to be an additional 15 years, the full 15 years. Whereas with the 131, which is the indictment that we're looking at now, original indictment, it would be, it's going to be, in his case, it would have been 5 years. It would have been exactly 5 years. And that could be concurrent. So it's a significantly more severe crime. But again, it's only shown here in the body of the indictment. It's not shown on the cover. So if you look, again, if you look at the face of the document, you'll think it's unchanged. But then hidden inside the body of the document, there's a significantly more severe crime being charged. And let me pull up. See, I'm going to put this in a different folder, actually. This is applicable to everybody, so that's why I have it in a different spot. This is the state's motion to dismiss the original indictment. In that document, they say all counts and offenses from the original indictment are incorporated into the reindictment in case number 22 SC 183572. So they represented to the court that the crimes are the same. Hey, Mary and Emily. So that's untrue. That is, they are mistaken. The Honorable District Attorney. And it's actually a worse thing. And let me see. Thanks for reminding me, Aaron. Smash that. I still can't do it. If you'd like to like and subscribe, I would appreciate that. This was in the, I believe, motion for default. Martinez Arnold. Here we go. Here, the state says, this is to Judge Glanville in the civil asset forfeiture action against defendants Williams, Young Thug, and Duke, aka Martinez Arnold. Said criminal case is reindicted on August 5th, 2022 under Fulton County Superior Court case number 22 SC 183572 and included the exact same crimes indicted in the original indictment plus 9 additional counts. So twice, in 2 different cases, they represented to the court that the crimes, I mean, I'll use this language. They say exact same, and then in the null pros, they say all counts and offenses are incorporated. So they repeatedly mistakenly misstated the truth. If you want to count the fact that the face of the document also misstates the truth, that's 3 misstatements of the truth with respect to the contents of the indictment. Okay, we're not going very fast here. We're going to have to keep going. I'm going to check and make sure you've been able to see all this stuff. Yeah, okay. This is great. We're not going very fast here. We're going to have to keep... There we go. Okay, sorry, just fixing some stream settings. Here we go. So, all other wording in the reindicted count 30 remained the same. Meaning the reindictment alleged exactly the same elements as in the original indictment, despite the fact that the reindictment's count 30 purported to charge 1611-133. Accordingly, despite the retitling, the reindictment continued to allege a violation of 131. Now, all that means is that despite the fact that they changed these parts that are highlighted, everything else is essentially this, not quite the same, but for all intents and purposes, everything else is the same. This part was changed. You see they changed the underlying offenses. They changed the name of the title in the code section, but everything else is the same. So as a result, the crime charged also didn't change. It remained 131. But the crime that they're describing in the reindictment is still possession of a firearm by a convicted felon. Hey, Candace. They say this is the felony of which he was convicted in orange. This, or the orange part is the felony of which he was convicted and the date of the conviction. This is the act. So what they're describing is just possession of a firearm by a convicted felon, which is still this crime right here, 131, which, as you'll remember, is the less severe crime. So they changed the name and the code section to a more severe crime, but the crime that they actually describe is the less severe crime. And they're not completely forthcoming with that change. So that is all this section here is saying. We're saying that they changed some of the wording around to make it sound like Antonio was being charged with a more severe crime, but in reality, they were still just alleging the much less severe crime. And this is going to be incredibly impactful on Antonio. It continues to be impactful upon Antonio. So, on December 1st, 2022, just 27 days prior to Antonio entering his plea, Bonnie Willis and Adrian Love filed the state's motion in limine on the substance of the indictment. In that motion, the state correctly argued that when the caption of an indictment, that means the face of it, when you look at the face of the document, and the substance of that indictment, the stuff that's inside, the meat and potatoes of it, the substance controls. That means the actual described crime. This is the part that you look at. You're not looking at this stuff up here. This you don't need to worry about. It's nice to have, and it should be accurate, absolutely, but what matters is the crime that you are actually describing, the acts that you are accusing the person of having done. That's just repeating what I said before. Thereafter, the state sent its first proposed plea agreement to Mr. Sledge through counsel on December 7th, 2022, the evening before the final plea hearing. You might remember from the first paragraph, I said that the plea was entered on December 28th. So, as I say, less than 24 hours later, on December 28th, Mr. Sledge entered a guilty plea pursuant to a negotiated plea agreement. Oh, good cat. I think I've gotten better at explaining stuff, but definitely jump in if there are any questions. I actually found out today that the time of the plea hearing was at about 4:30. So it was about 2 hours after the draft of the final plea agreement was emailed by Love to what's his face? Moonk's prior lawyer. I can't think of his name. I just have Tyrone Dennis's name stuck in my head. Derek Wright. Derek Wright. Okay, so all in all, Antonio had he couldn't sleep on it or consider the agreement. He had less than 2 hours to decide, and that's the absolute maximum. It was probably significantly less than that, to ask questions, to think about it. Thanks, Aaron. I got there eventually. Great, Matthew. I should know that name. I know Tiffany said that he He actually asked Tiffany about Mounk the other week, or I think last week. So he's keeping up on and checking in with him. Okay. So less than 24 hours later, he entered a guilty plea. The final plea agreement is attached. The transcript is also attached. Throughout the plea hearing, the state repeatedly interchanged the terms possession of a firearm by a convicted felon and possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Okay, this is one aside. I've never heard anybody use this term before to describe that crime. And the funny thing is that it doesn't actually describe the crime they think it does. Both of these describe this crime here, 131. Yeah, that's right, Aaron. That's right. That was the first emailed version, and they'd been discussing the case since at the very latest, the end of November. So they waited until the night before just to put extra pressure on him to get a guilty plea, because they didn't want him to actually have the opportunity to think about, the offer and consider it. They just wanted to exploit the situation as much as possible. Okay. So the important part about this here, throughout the plea hearing, they changed the terminology, is the state doesn't understand what crimes they are charging. Either they don't understand or they're lying. It's one or the other. You can choose which one. Doesn't matter to me. They're both bad. And they were conflating the two crimes. And a guilty plea has to be knowing, and you have to intentionally be pleading guilty to the specific crime. There can't be any confusion about the crime. But the state doesn't know their crime because they keep switching back and forth. And so the next thing I'm going to do is give examples of some of those, of the state not knowing what it's talking about. The first time Antonio's charges were identified during the plea hearing was in the following exchange between Love and Sledge. Maybe I should pull up the transcript. Let me do that. I'll show you the original. That might make it make sense. Make sure I don't have too many notes in this one. Yeah, this looks fine. Close this. Do you understand that you were charged? So this is what we're looking at here. Make sure you can see this all right. Yeah. This is the transcript. It's page 5. Do you understand that you were charged with the following offenses? He says, yes, ma'am. Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. Yes. As well as, important, possession of a firearm by a convicted felon as listed in count 30 of this indictment. So this is the first instance in which she states the crime that she thinks she's charging. But again, this is not what count 30 actually says. She's mistaken. She's misspeaking. What it actually says is this. So she did not know the crime that she was coercing a guilty plea to. She had no idea what she was doing. That's what I'm quoting here. Put it in bold. So she was completely wrong about that. Oh, hey, Shamrock. See you there. Next, on page 7. It's nice of me to put the lines there so I can find it when I'm streaming it later. Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as in OCGA 16-11-133, is 15 years in prison? This is also not necessarily true. It can be probated, but that's just a phrasing thing. That's not a big deal. what did I say? Page 7, 6 to 19, I think. 16 to 19. Here we go. See right here. Do you understand the sentence for violation of count 30? Possession of a firearm by a convicted felon as an OCGA 1611-133 is 15 years. This is insane. This is where it gets really wacky. She says possession of a firearm by a convicted felon. That's what she starts with. Show you this here. Possession of a firearm by a convicted felon. Then she says, as in OCGA 133. But that's a completely different crime. See? That is this crime here. So what she did was, in the middle of the sentence, she changed the crime. In the same sentence, she referred to two different crimes. Possession of a firearm by a convicted felon is 131. Then she says, as in 133. So, as I say, ADA Love changed the charge mid-sentence, beginning with possession of a firearm by a convicted felon, concluding with as an OCGA 133. All right, what's next? Later in the plea hearing, Mr. Chamberlain, Judge Glanville's litigation manager, credit to him, by the way, he was on it. I know people have kind of a negative perception of Judge Glanville, but he actually caught almost every mistake. So I have no ill will toward Judge Glanville on this matter. I think he got confused by the extent of the ineptitude, to borrow from Emily C. Later in the plea hearing, Mr. Chamberlain, Judge Glanville's litigation manager, while discussing if Mr. Sledge could be released without a sentence on count 30. Actually, let me just show you the plea agreement first. That will contextualize this. Make sure this is marked up. Yeah. This is not really the final plea agreement. I don't know what you're talking about, Aaron. Let me see. So this is count 30. You'll notice that it calls for sentencing to be withheld until the completion of the initial trial of this case. The problem is that if he's not being sentenced and the court needs to do something with him, because they can't just let him go. He needs to either have a sentence or a bond. There needs to be some reason why he's leaving the jail. And so that's the issue that Mr. Chamberlain raises. This is just another example of me discussing the confusion between 131 and 133. But yeah, that was one of the issues that he raised. Now you'll notice the actual sentence. Where are you? There you are. This is fine. It splits the difference. Possession of firearm by convicted felon. Okay, that's fine. That's correct. 1611-131B, also correct. Guilty, correct. The problem is this. This is incorrect. This 15 years to serve on probation, this refers to 1611-133. That's the only... 133 can't have a 15-year sentence. So this part's 130. Put this in a different color, actually. The two laws are kind of being combined. It's kind of a mishmash of the two. They're taking the easier to prove crime, and they're taking the sentence, the more severe sentence of the crime that's harder to charge. So they're kind of taking the best of both worlds. And again, you see here consecutive to count 1. That's also from 133. So you have these two different laws, these two different violations on the same count. That is where the mistake came from. The inaccuracy came from. So just to summarize that part, the state didn't know what crime it was charging, or they knew and they didn't care. They misstated the crime, confused the judge, and got a 15-year sentence consecutive when it should have been 5 years and likely would have been concurrent. So as a result, let's go back to the disposition. If this had been correct, this part would have been correct. It most likely would have been 5 years to serve on probation. And then this would have been concurrent to count 1. So as a result, his total sentence most likely would have been 15 years. I keep trying to capitalize that. 15 years. So effectively, the mistake doubled his sentence from 15 years to 30. That's a big difference. And remember, it's not just that he's actually serving, well, not anymore because, stuff happened, but originally he was serving a 30-year sentence. But you also have to remember that they were using the threat of the 30-year sentence as leverage in the plea negotiations. So they were exploiting their own illegal threat to get him to plead guilty. Aaron, they did, actually. They did. That's a whole different... we'll be getting into that soon. Not in this motion, but I have thoughts on the recidivist. I want to talk about it, but I'm going to keep things in order. We'll talk about it soon. But yeah, so they were using the threat of an illegal sentence to get the illegal sentence. It's just layers of mistakes or misstatements of however, whatever euphemism you want to use for flagrantly lying. Okay, so that's where we stand at this point. We go to the next part. Mr. Sledge's final plea agreement. I actually want to show you something. This was a little cheeky thing that I did. This footnote is incredibly important. This is one of the most important, probably the most important parts of one of the most important parts of the document, most important footnote by far. Though beyond the scope of this motion, Mr. Sledge does not concede or waive any arguments or rights with respect to the final plea agreement or any drafts or version thereof. Final plea agreement is used for simplicity. All I'm saying is that the final plea agreement, what we're calling the final plea agreement, we're not admitting or accepting that it's actually the final plea agreement. And that would become the entire basis for the second motion that we wrote, and that we'll be discussing on appeal. But we wanted to make clear that we did not, what they called the final plea agreement was absolutely not the final plea agreement. So let's go back to where we were. Hopefully I can remember. Oh, it's going to be so hard not to go off script at this part. Okay, so we had to testify, as some of you may recall. After we testified, the state filed its motion and petition to revoke probation because we're salty, which is attached as Exhibit G. In the petition to revoke, Adam stated that Mr. Sledge pleaded guilty to conspiracy. Hey, James. To violate the Right to Influence and Corrupt Organizations Act and possession of a firearm by a convicted felon. Exactly, Kat. So, Aaron, I've used less than half of what I'm going to use. I'm confident that the state wanted the court to grant the first motion. Yeah, so Abate was just referencing this part, which is fine. Oop. Still see everything? Looks like it. At the evidentiary hearing, in quotation marks, regarding the petition to revoke because they're salty, the court took judicial notice of Mr. Sledge's testimony from trial and ruled that Mr. Sledge has violated the special conditions of probation as alleged in the petition for revocation. This is a major point in the second motion, but I'm not. We're just doing the first motion today, so I won't get into that in too much detail. The court then revoked 5 years of Mr. Sledge's 30-year sentence in order that he be reinstated on probation upon release. I'm trying, Kat. I'm trying to walk that line between being condescending and helpful. So if I do sound condescending, it's not intentional. Unless I'm talking about the prosecutors. Citation of authority and argument. This is actually some background, just some insight into my process in writing this. It was really hard to decide which part would be argument and which part would be just facts, because the facts are so obviously contrary to the state's position that just stating what happened felt like I was arguing. So that was a trip. Part 1. Hey, James, if you have any questions, just ask. I'm happy to go back and explain things, because I'm sure you're not the only one. So, in the context of a criminal conviction, a sentence is void if the court imposes punishment that the law does not allow. That's Parrott versus State. That's a Supreme Court case, quoting Von Thomas and Hendricks versus State. This is true even for defendants who plead guilty, because a defendant who knowingly enters into a plea agreement does not waive the right to challenge an illegal and void sentence. That's good, Snarky. Nancy, this one was decided on the briefs. We won in part. We got 10 years of his sentence vacated, but we appealed it. The part that we didn't win, because we should have won. But we can win on other grounds now. It probably won't even come up. Honestly, all of this stuff and the next level at the appellate level probably won't even. It won't even be the first section. It might not even be the second section. It'll be towards the back of the brief. There's more important stuff that we have to discuss. So all this part means is that if you get an illegal sentence like this, it doesn't matter if you get it because you pled guilty. You can't have an excessive sentence. It's just not a thing. And if you do get an excessive sentence, it's just void. And the court needs to go back and redo it. So a sentence entered in a criminal case, which is void, it remains void until the court imposes a legal sentence. Until that happens, Kat, no, it turns out we have to go to the appellate court first. She wants us to do the appeal on the first motion before she rules on the second, which is fine. We knew there was a chance that would happen. Some courts will exercise jurisdiction to fix their own mistakes, but she just wanted us to go to the appeal. So yeah, a sentence entered in a criminal case, which is unauthorized by law, is null and void until the court imposes a valid sentence. Until the court does so, the criminal defendant stands as though convicted, but not sentenced. This is why, although a sentencing court lacks jurisdiction to modify a sentence after a certain period of time, if the original sentence is illegal, the court may resentence at any time. I do too, James. This is just a jurisdictional issue. It means the court can exercise control over Mr. Sledge. Normally, it's the court can after a year or a term of court, depending on the time period. This drives me crazy because this should have been on the next page. You shouldn't have a header at the bottom of a page like that. That's my bad. So this part is just about discussing the fact that as it says, sentencing courts enjoy broad discretion in resentencing partially void sentences. The Georgia Supreme Court acknowledges that its handling of sentences that could be characterized as partially void may appear to be inconsistent, meaning they don't pick any single approach to resentencing. In some cases, where only a portion of a sentence, such as a parole condition, was found to be unlawful, the court vacated only that specific condition. In other substantially similar cases, the Supreme Court has vacated an entire sentence and remanded for resentencing. So say you have, let's say, 5 sentences. You've been convicted of 5 counts and you have 5 sentences, and one of the 5 is void. They can void all 5, or they can void just one. If you have one sentence that has 3 different parts and one of the 3 parts is void, you can void just that one part on that one sentence, or you can void all 3. Basically, anytime you have a sentence and some subpart of it is void, you can void just that part or the entire thing. That's the simplest way to say it. I like this sentence. Far from inconsistent, pertinent precedent illuminates twin maxims. Trial courts are generally afforded broad discretion in resentencing, and trial courts are not required to adopt a single exclusive method for exercising that discretion. Hey, Breezy. It probably will go before Whitaker again, but it's going to go to the appeals court first. Accordingly, sentencing courts have vacated the entirety of a partly void sentence in a variety of contexts. Again, Parrot, I think I messed the citation up. This should have been short form. There we go. All better. How did I mess this up? This is embarrassing. That's fine. I won. In Parrot, the Supreme Court specifically expressed no opinions whether the trial court could also resentence on other counts for which the sentences are not void to preserve an overall sentencing scheme. I'm going to read the next part, then I'll explain that. The Supreme Court took time to explicitly clarify the 2 prior cases in which the court ordered only the void portion of a sentence stricken, really emphasize which part of a sentence on a particular count the trial court was required to vacate, as opposed to limiting the trial court's discretion. Nancy, we filed a while ago, so it should be pretty soon. I mean, that's relative, certainly. I will say that selfishly, if everything else were equal, and Mounk Tounk, if he were home right now and he were doing like house arrest or something, I don't know. If he were at home and not waiting in prison, I would be so happy that we get to do this appeal, because I get to use all this. I get to use everything. I get to use all of the wrongdoing that happened in his case. Whereas in this motion, I was super limited on what subject matter I could cover. So, like, strictly from a legal lawyer perspective, it's exciting. I get to get into the non-existent crimes that he previously committed. I get to talk about the district attorneys perjuring themselves. It's going to be fun. So all this part is saying is that courts they have a great deal of discretion when they resentence after the initial sentence was found void. They can void the whole thing. They can throw the whole thing out. They can throw part of it out. They can pretty much do whatever they want. In Clue, the trial court determined that Clue, the defendant, had received ineffective assistance of counsel during plea negotiations, but only as to 4 of the 6 counts. Clue subsequently filed a timely motion to withdraw his guilty plea, which was granted as to the same 4 counts and denied as to the remaining 2. The Court of Appeals held that the denial constituted an abuse of discretion because the ineffective assistance as to the 4 counts undermined the voluntariness of Clue's plea to the remaining 2 counts. And 2 is related to the first one. The defendant's negotiated plea agreement was a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. I have an idea. This calls for Microsoft Paint. Let's see how well I know streaming software. Ooh, not very well. Aw, man. Let's try this new streaming software I got. New drawing software. See if that'll work. Here we go. Excited about this. I really think this will help clarify. What's it called? Illustration? Well, no. Here we go. So I think this will explain the issue that we're talking about in that section. Get the real G pen. All right. So let's say we have plea. Let me see. And you have part. So this is your sentence. Now, if you have the, let me see, trying to fix this. All right. Now, count 1, 2, and 3 are legal, and we'll say count 4 is illegal because you can't have an indefinite sentence, and you can't be sentenced to something until you get your act together. That's not a thing. So what the court will do, what they can do, is they can get rid of just this. So they can make this for 5 years, and that would be a fixed period of time, so that would be legal. They can get rid of everything. Oh, I didn't know I could do that. And start over. Basically, they can do whatever they want, but they have a lot of options. That is my point. So they could resentence to 1 year on each of these. They just have a great deal of discretion. But yeah. That is all that part says. Kaiser 1. I don't think we need to get into that. It's actually important. In Kaiser 1, Kaiser, a physician, entered into a negotiated plea agreement. Pursuant to a negotiated plea agreement, Kaiser pled guilty to more than 60 counts and received a 30-year sentence. At the plea hearing, the sentencing court, on its own, added a special condition of probation, rendering the sentence not for a fixed period of time. It made it indefinite, and you can't have an indefinite sentence. So it was therefore void. The condition that he added was actually that Kaiser could never practice medicine again. Nancy, I'd have to check. I believe it was 5 years, so he hasn't gotten a date yet. So it'd probably be like 2 years. But I wouldn't be surprised if it was a little bit more than that. It could be up to, if it's the full 5 years, it would be 2029. It would be October 18th, 2029. So at the plea hearing, the court added the condition making the sentence indefinite and therefore void. Treating the negotiated plea agreement as a package deal, the Court of Appeals vacated the entire sentence and remanded for resentencing. And so holding, the court observed that in many circumstances, it is appropriate to view the final negotiated plea agreement as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. All that means is that when you do a plea agreement, you're usually addressing every crime. You're treating everything collectively. So you can't just start to pick and choose, which parts to keep and which parts to throw out. If you have a package deal plea agreement, you either keep the whole thing or you toss the whole thing. That's basically the way it goes. And if the court needs to void a part of it, it should void the entire thing. Because, again, you can't just pick and choose. It all fits together. Let me see. Oh, it's good to take a break. Breezy says, can you tell us how Mounk is these days? Yeah, he's actually annoyingly positive. He's a very positive guy. He's excited to get home. He's obviously not happy with the situation. But, yeah, he's in high spirits. He needs to write a book or something. James, if you find that case, you should share it, or you can message me or something. Oh, I wonder. I might know. Is this a Fulton County case? I might know who it is. I might know which case you're talking about. There's a lawyer who asked me about that case. After we filed this motion. The 15-year sentence on count 30 is void because it exceeds the statutory maximum of 10 years. This one is difficult because 15 is more than 10, and it was really hard not to sound like condescending to the court or just to say anything more than, I don't know, man, 15 is more than 10. What do you want from me? But here you go. Sentences of a length exceeding the statutory maximum term sentences are void. That means if it's a 15-year sentence on a crime that can only be up to 10 years, it's void. Here, there is undeniable evidence that on December 28, 2022, Mr. Sledge pled to possession of a firearm by convicted felon, 131, and not 133. Therefore, the maximum sentence prescribed by law was 10 years. It's really probably 5, but I didn't want to argue. We didn't want to argue over whether it was 5 or 10, so we just said 10. It's the same result either way. Since Mr. Sledge says 15, his sentence exceeds the maximum and is void. Given that his guilty plea was entered pursuant to a package deal, the sentence on count 1 should be vacated as well. Remember here, this is his plea agreement. You'll see that it all relates together. This is a package deal. It's dealing with both counts together. Trenton, I did actually. I did one time. But that's because someone reminded me. So maybe no. Yeah, so it's a package deal. So if you're going to get rid of this part, you got to get rid of this part too. You need to start over. The reindictment of this case under 13572 made 2 alterations. This is just discussing why it's a package deal. We don't really need to get into that, but the point is that the sentence on counts 1 and 30 were negotiated together. They're negotiated jointly. It's clearly a package deal, and the entire thing should be vacated. Go to the disposition. Both of these were entered pursuant to a negotiated plea agreement, as you see here. It's a package deal. The entire thing should be tossed. So here, the court should vacate the entire thing because it was imposed pursuant to a package deal. The final plea agreement was based on the shared misunderstanding that count 30 charged 133. Sentences imposed pursuant to 133 must be for a term of 15 years and must be run consecutively to all other sentences. Mr. Sledge is led to believe that count 30 charged 133. Thus, he sensibly and successfully negotiated for concessions with respect to count 30, as if it charged 133. He secured a promise that count 30 could be dismissed, the sentence could be suspended, and that the sentence could be served on probation. And that's true. In the plea negotiations, he was trying to mitigate the effect of count 30, thinking that it was the more severe crime, more severe sentence, that it was a thing that would keep him in prison. So in business terms, you could say that he expended his negotiating capital or his deal capital on count 30, when if he had known that it charged 131, he wouldn't have done so. There would have been essentially no point, and he would have focused on count 1, on negotiating on count 1. So the deception as to count 30 affects the sentence on count 1. If the state had accurately stated count 30, it would have impacted count 1. And so you can't disconnect counts 1 and 30 for a variety of reasons. I like this sentence. I like these sentences. From Mr. Sledge's perspective, those were the most critical points of the plea negotiations. That count 30, in fact, charges 131, renders the concessions that he negotiated pointless. You might say that the point is pointless. 131 carries a maximum sentence of either 5 or 10 years, depending on the circumstances, and can be run concurrent with other sentences. Thus, had Mr. Sledge known the true charges and the corresponding sentences, he would have approached negotiations differently. Quoting like in Clue, where the ineffective assistance undermined the voluntariness of his guilty plea, here the flaws in the reindictment undermine the voluntariness of Mr. Sledge's guilty pleas as to both counts 1 and 30. Essentially, because he didn't understand, because nobody understood, neither the state, the court, or Mr. Sledge understood the count on count 30, the mistakes rendered that guilty plea involuntary. I think that's just objectively true. Accordingly, the court should treat the sentence as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. Thus, the court should find Mr. Sledge's entire sentence void and vacated. Conditions of probation are applicable to both counts 1 and 30. I think this is a short section. Yeah. There are no doubts Mr. Sledge's final plea agreement was a package deal, as Mr. Sledge would have the opportunity to withdraw his plea to count 30 and have that count dismissed, thus leaving a conviction for only count 1. Thus, or also, the sentencing conditions imposed address and govern both counts. Thus, sentencing on both counts was done in tandem and cannot be separated. The state treated the sentences as a package deal when it was in the state's interest to do so. Mr. Sledge accepts the state's characterization, and the state should be held to that position. Accordingly, both sentences are void and should be vacated. I'm going to come back to this part in a second. I just want to finish this first. This sentence here. Oh, Mary, I'm telling you, the stuff that I've talked about so far isn't even the bad stuff. I'm holding back on the actual bad stuff. It gets so much worse than this. What I will say is that he's never been found guilty, so he's actually not even been adjudicated as a guilty person. So he's literally an innocent man sitting in prison. Wherefore, the fact that Mr. Sledge's sentence on count 30 of the reindictment exceeds the statutory maximum for the offense. I don't know how to read wherefore sentences, I swear to God. I hate Georgia, drives me crazy. Wherefore, the fact that Mr. Sledge's sentence on count 30 of the reindictment exceeds the statutory maximum for the offense of possession of a firearm by a convicted felon renders the judgment void, and it must be vacated as a matter of law. The final plea agreement was a package deal, and the court should not treat its terms in isolation. Mr. Sledge's entire sentence is void and should be vacated as a matter of law. This court should also vacate the revocation of Mr. Sledge's probation, given that the underlying sentence on which Mr. Sledge's probation is based is void. Both the probated and revoked portions of that probated sentence are likewise void. This just says that count 1 and 30 are void. And because both counts are void, the probation revocation is also void because that's just a part of count 1. We did know, in fact, that the revocation came from count 1, just in case there's any confusion. A void sentence is one that a court was without authority to impose in the first place, and any actions taken under that void sentence, including revocation, are considered void as well. Mr. Sledge reserves his right to withdraw his plea and exercise his constitutional right to a jury trial at any time prior to sentencing. Sorry, I got carried away there. Respectfully submitted this 23rd day of April. My beautiful fake signature. Okay, so let's look at the ruling on that real quick. Go back to my... I have some notes on here, but nothing important. I felt the need to highlight the part that said I was correct, apparently. Okay. Let's get into Judge Whitaker's order on that motion. On April 23rd, we filed that motion. Alleging the sentence imposed by the sentencing court exceeded the statutory maximum. Defendant is correct. Let's just highlight that again. I don't want that to get lost. Here we go. As he admits in his motion, Mr. Sledge entered a plea to 131. However, he was sentenced on count 30 for violation of 131B to 15 years consecutive to the sentence of 15 years probation imposed for count 1. The available sentencing range for 131 was 1 to 5 years. That's actually not correct, but it doesn't matter. Because the sentence imposed exceeded the permissible sentence for violating 131, his sentence on count 30 is void. Defendant's motion to vacate as void as sentence on count 30 is granted, and defendant is hereby resentenced on count 30 to 5 years. Probated. Oh, thanks, James. Consecutive to count 1. I'm definitely going to look at that. I'm going to write that down, actually. That's crazy. Okay. So one thing I want to notice here is it's consecutive, and I have to imagine that that is because the original sentence was consecutive. Because 131 does not have to be run consecutively, it can be run concurrently, whereas 131 is mandatory. So I think that this part, the consecutive sentencing, is most likely a vestige of the illegal sentence in the first place. So it's kind of a remainder of the illegal sentence. It's a carryover of the illegal sentence, which is a shame. See in our motion, reserves his right to withdraw his plea. That was not observed. He was sentenced in his absence, which is illegal. So that's 3 or 4 reversible errors already. Defendant also argues within the conclusion of his motion to vacate that the court should vacate the October 18th revocation. That's what we didn't argue. We argued in the argument section, not in the conclusion section. That's why he posits that because the underlying sentence on which Mr. Sledge's probation is based is void, both the probated and revoked portions of that probated sentence are likewise void. That skips a step. That skips the entire package deal portion of the argument, which is the centerpiece of our motion. The reason we're saying the entire sentence is void is because of the package deal. We're saying 30 is void because it exceeds the statutory maximum, and count 1 is void because of the package deal. Essentially, the illegality of count 30 carries over to count 1, and the entire thing's out. What the court says, here defendant is incorrect. The revoking court revoked only the first 5 years of what was then a 30-year probated sentence. 15 years on count 1, followed by an incorrect 15 years on count 30. True. Because the revoked 5 years was part of the 15 years probation he was then serving on count 1, and not any portion of the now vacated consecutive 15 years he had remained to serve on count 30, the vacature as void of the 15-year consecutive sentence does not impact the revocation of the first 5 years of his then 30, now 20-year total sentence. The court did not address the package deal. That's the misunderstanding. We know that the vacature of count 30 in and of itself doesn't impact the revocation, which relates to the first 15 years. We knew that. It's the package deal issue that caused the count 1 to be vacated. Hey, Trakisha. So that was an issue. I want to show you a couple things that I highlighted in the motion. I'll go back to 1 or 2 things. This part here. The state treated these sentences as a package deal when it was in the state's interest to do so. That was a specific, I was referencing something specific there. You probably aren't surprised to hear that. Here we go. Is there too many comments in here? I don't want to show you any work product. This looks fine. This is Adam Abate's motion and petition to revoke probation. I want to show you this part here. This sentence. On October 28th, the defendant pleaded guilty to conspiracy to violate the racketeer influence and corrupt practice. I've been doing this for years. I mixed up the Foreign Corrupt Practices Act with RICO, and so I always say the Racketeer Influence and Corrupt Practices Act. I'll probably do it in front of a judge at some point. It'll be embarrassing, but that's okay. This conceals the illegal sentence. I'm sure it's a mistake. The maximum sentence for RICO is 20 years. You know what? I don't know. I can just type it. Max. Not short. Equals 20 years. The maximum for possession of firearm by a convicted felon, I guess I'll put it right underneath. So coincidentally, I don't need this. You guys understand what I'm saying. Total maximum sentence, 30 years. So, by stating the sentence in the aggregate as 30-year sentence, rather than, if they were separate, saying 15 years on one and 15 years on the second, they're hiding the illegal sentence in the face of the document once again. For the millionth time, if you look at the face of the document, you can say, oh, this is a legal sentence, because 30 years for a RICO and possession of a firearm by a convicted felon is a legal sentence. But if you don't treat them as a package deal, and you treat them as separate 15-year sentences, which is what they were, under, the theory that the state, now wants to adopt, apparently, or as the court described it, it's clearly an illegal sentence. So by saying it as a package deal, the state hid the illegality from the court. And so when I said it was in the state's interest to treat it as a package deal, that's what I'm talking about. They used the fact that it was a package deal to hide the illegal sentence. Maybe it was I'm not saying it was on purpose, but yeah. That is the effect of it, irrespective of whether it was on purpose. I think there was one other one that I wanted to show. Ooh, this is a fun. Actually, no, I'll get to this in the next section we cover. Is there anything else I need to show, though? Oh, right. This is the last part. So this is the sentence that was entered after this order. This is the second part of the court's. Oh, wait a minute. Thanks for reminding me about that one, James. Here we go. This is... Man, I feel like it needs to be the exact right size. It drives me crazy when it's not. Okay. So this is what we just read through. Or, no, not this one. This part. The court's order on the motion that we just read through. This is the sentence that was entered at the same time. So this is kind of puts into effect the court's order on our motion. So this was all on April 28th. You'll see it's right around the end of the day. I think it was the same time. Yeah. We're in it together. But a couple things to note here. Yeah, I'm going to go over that, Aaron. A couple things. First of all, you see, no, not you. Negotiated plea. There was absolutely never any negotiated plea. In which, Mounk agreed to a 5-year probated sentence on count 30. So there just wasn't a plea agreement to that effect. So it wasn't subject to a negotiated plea agreement. That's just incorrect. That's objectively wrong. And I mean, it's even in the final order, I believe. There you go. Defendant is hereby resentenced to 5 years probated. But there's no plea agreement for that. So it says negotiate plea agreement. I don't know what happened there. This stuff we'll discuss in the next. It'll probably be a separate stream. Yeah, this will be part of the second stream. But you'll also notice here it says the Honorable Tiffany G. Adams represented the defendant, but there was no sentencing hearing. So she didn't. I mean, obviously Tiffany represents Mounk, Tounk in general and in the motion, but he wasn't represented. She didn't represent him in any plea negotiations in connection with any sentencing or resentencing. So I don't know where that came from. That's just incorrect. So this is just it's a mess, and that's not even all the problems. Oh, James, I mix that up all the time. I have to Google it constantly. I know there's a Y, and sometimes it's like, is the Y in Simone or is it in Hilton? She's super nice, by the way. In person. Never litigated against her, but she's very pleasant. Where was like, oh yeah, James brought this up. Let's go to you. Here we go. Let me just pull up the revocation hearing on YouTube.
All right. You know what? I think I'm still on Zoom. Yeah.
Not you.
And what's the officer's name?
There we go.
Oh, it's my regular probation officer from.
The exact number.
On the person, give him an even greater sentence. So we would.
That would be correct, Your Honor. In addition,
Hold on, let me check the transcript so I can get you the right timestamp. Sorry about this. I wasn't planning on showing this, so I'm kind of doing it on the fly here. 4023.
Maybe it was revoked, but it was just wrapped up in something else.
No
is
comment.
how I would take that. I don't know, but or that a violation was found, but we don't know what that was or anything like that. All right. So does probation have a recommendation in this case?
due to the last minute notification of this probation revocation, I will leave that up to the courts to make that decision.
Okay. All right. Well, I find there to have been a violation.
This is not even the part I was looking for. Where are you? I'm looking for Mr. Abate. Sorry about this. Here we go. $40.48. Here we go.
I would leave that up to the courts to make that decision.
Okay. All right. Well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right. Well.
So you notice he didn't state a number of years in the motion. Let me pull this up for myself. Motion to revoke. Do I still have it open? I'm gonna reopen that. The state asked for let me see what's up here. Yeah, here it is. Explain why his probated sentence should not be revoked in its entirety. The problem is, you notice that Abate didn't say that. He didn't argue for that. And even here, he's saying that Mounk should be ordered to appear, explain why it should not be revoked in its entirety. He never says a number of years. And by avoiding making the recommendation to the court or stating a number of years, he never advocates for the enforcement of an illegal sentence. So he manages to sidestep that particular ethical dilemma. Let's see, what did... I think she knew the mistakes were made. No, I don't think so. I actually think there's a moment in this hearing. I'm not going to pull that up for you. I think she suspects something's going on, but she can't quite put her finger on it. That is at 39:20. I'll show you that. This is just a theory of mine. It's not legal analysis. I can go back a little further.
Are you looking about prior revocation?
First degree, criminal damage, second degree, and possession with a firearm by a convicted felon. That was January 10th. Firearm by a convicted felon.
Just a minute or two.
That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
So this relates to the court, to the claim that Antonio Sledge has used his first offender status 3 times. That's ridiculous. He's used it once. But here Whitaker's catching on. She's confused because if you accept that there are multiple first offender statuses, then he can't have had one of the convictions that they claim that he had. So she's picking up on the fact that she's confused because what they're saying doesn't make sense, and see what happens afterwards. You also notice the probation. I don't think the probation officer did anything wrong. She just didn't have the full history in front of her. But there's confusion between both Whitaker and the probation officer, and see how that confusion resolves.
One
Or are we
moment.
missing a felony?
One moment.
Yep, exactly right, James.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on. So the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay.
More confusion.
Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the 15
I
SC.
figured there had to be something else there.
That was the predicate offense. The predicate conviction for the conviction of possession of a firearm by a convicted felon in the 15 SC case. That would be the predicate conviction. Let's just listen to that one more time. It was beautiful. Let's see what he says exactly.
Received 5 years probation on January 7th, 2014.
Now we go back a little bit.
Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the 15
I figured
SC.
there had to be something else there.
That would be, I transcribed this. That conviction would be the predicate or basis for the possession of a firearm by a convicted felon conviction on the 15 SC case. So he's making a specific representation as to the predicate conviction for the conviction of possession of a firearm by a convicted felon in the 15 SC case. If anyone can go ahead and stop me once you see a conviction for possession of a firearm by a convicted felon in the 15 SC case. I don't know where to scroll and stop because it's not on here anywhere. So, I mean, I'm wonderfully curious as to the basis for his, the factual basis for his claim that the 13 SC case served as the predicate conviction of something that doesn't exist. Makes you wonder. Makes you think. Oh, man. So that is probably more than I should have said about the first motion. Yeah, but that's probably what it is, Kat. But the problem is, like, 106 doesn't require a predicate. So, I mean, that's probably what it was, but you still wouldn't have a basis for the claim. It still wouldn't make sense. I wish this was stronger and boozier. But yeah. So it's a completely baseless claim on his part, and it covers up a mistake that was made in the it's a misstatement that covers up another misstatement. Which is, it's remarkably fortunate that that these mistakes keep pulling in the same direction. It's really fortunate. It's coincidental and fortunate. Shoot, lock corners. Cat, they've done like lock corners on most of the stuff. It just, So yeah, that is a tiny fraction of the stuff that I will get to argue. Buzz Boss Squad. The Hobuzz. Cat, that's what I need. Are you guys familiar with Hobuzz? Or are you? There we are. This is just a delight, really. No. Oh, Pet, the Retro 51. We get the Bailey. It's like a Montbard, maybe? Never mind. High-profile Houston attorney, reality star, acts THC Seltzer partnership. After less than a year on the shelves, the controversial Hobuzz line is no longer in operation. This is Tony Busby, and this is, I guess, a reality TV star. Washington Ho. They collaborated for the Hobuzz brand. Tony Busby always looks like he's photoshopped. Like, that's just what he looks like, though. In late 2023, Houston reality TV star and businessman Washington Ho partnered with superstar lawyer Tony Busby to create Hobuzz, a new Delta 8 THC spiked seltzer. Now, less than a year later, the brand has splintered. In an interview with Cron, founder Tony Busby confirmed the end to the short-lived partnership. Busby said that he is still in business with Eighth Wonder, which was acquired by Bayou City Hemp in June 2023. The Houston attorney is an investor in the brewery and will continue to collaborate with Eighth Wonder for another seltzer, Patriot Brands. Taking its name from the former Hobuzz's Patriot flavor, Busby is planning to launch Patriot Brands on July 4th in partnership with Eighth Wonder and his son, Anthony Busby Jr. The brand, Busby said, is veteran-owned and operated. The first seltzer flavor is a low-dose lemon lime beverage, clocking it around 5 milligrams of Delta 8, Delta 9 THC. Other products, including iced tea and cola-flavored seltzers, are in development. The Houston Business Journal reported Washington Ho left Hobuzz to focus on entering the cannabis industry through the Bahama Mama chain. Ho is also behind several real estate development projects, including a $20 million retail space and the Little Saigon neighborhood. Ho told HBJ that Eighth Wonder Brewery had not produced enough to expand the business, and that other considerations, including the shaky legal status of Delta 8 THC in Texas, contributed to the partnership's end. Pour one out for the Hobuzz. However, in an interview with Cron, Busby refuted Ho's account. He can't even agree with somebody who's giving an amicable, an amicable, justification for the business falling apart. In an interview, Busby refuted Ho's account. Busby said he dissolved the HoBuzz brand and denied that Delta 8 THC's legality was a motivating factor. I think the opposite would be true, of course, Busby said. I invested millions of dollars into Eighth Wonder and Bayou City's hemp's merger to pursue and develop the market for these drinks. Busby said that as an investor in Eighth Wonder, he is particularly interested in developing a product that is accessible. Accessible? That's not the word I would use. I don't know if I want weed being more accessible to like children. Let's just make it more, more available. I don't know. A non-alcoholic alternative to alcohol. I think most alternatives to alcohol are non-alcoholic. I think it's one of the requirements, in fact, as well as learning more about the THC-laced beverage market. I wouldn't have used the word laced either. Busby said that with the Patriot line, he hopes to scale the seltzer brand larger and has set sights on making it available at grocery stores and liquor stores. Oh, do you know Eighth Wonder? Are they good? I don't know them. I was a bartender in a beer bar once upon a time. I was just liking that one. That was painful. Oh, Ken Paxton, you just mentioned him. When his first launch, HoBuzz had attracted much attention for the THC nature of the seltzer, along with the big names behind its brand. At the time, Busby had announced that he would represent Texas Attorney General Ken Paxton at his impeachment trial. James. That was an excellent call. Busby also announced his candidacy for City Council District G seat, which he then lost to incumbent Mary Hoffman in 23. Oh, man. Oh, new Fogo de Chao in Houston. You'd love to see it. Oh, man, I'm getting a headache from all that nonsense. Oh, the producer. I was thinking, okay. He always looks Photoshop. Am I wrong? Oh, too far. Like, it just looks like his head's Photoshopped on. Okay, so I think I'm going to do the second motion separately. Probably Monday. Maybe tomorrow. I'll let you guys know, though. I hope that was helpful in some way. But yeah. Let me know if you have any questions or anything. I was happy to cover it. But I'm excited where this case is going, where Moontung's case is going. I feel good about it. I wish it was happening faster, of course, but it is what it is. It's cheap on the fiber. All right, guys. Great. Glad to hear it, Mary. I'm gonna call it a night. I gotta make dinner. But yeah. Thank you for tuning in, and I'll see you guys soon.